in the middle. But always in the middle, but never, not always not on a middle path.
My friend will start. What has happened is in the judgments which are uploaded, some of the judgments on which all of us will rely, that is Satyanarayan, Deepak Agarwal, Vinay Mishra, Dheeraj Moore, SCR has been uploaded. Now, SCR's paras are totally different. Yesterday night. So what I've done is, of the 6 main judgments, I have made an SCC compilation so that your lordship can see that, because all our written submissions are also on SCC paragraph numbers.
Most of them, latest volume has been updated.
You can airdrop us also.
Which also has the SCC. It's there. Actually, my lord,
because these 6, everybody will be referring.
There is a circular which has created this confusion. That circular says for constitution benches, when you circulate judgments, it must be the SCR. In fact, I think your lordship should update that circular because because
We have a SCC. No?
yeah, so the only 2 judgments that I will be referring from the SCR, my lord, are Chandra Mohan and Rameshwar Dayal, which are pre-SCC, pre-1969. I'll read those from the SCR. Remaining judgments that I refer to will be from the SCC.
So here in this, these 6.
Well, it's in fact, Rameshwar Dayal, for example, now my learned friend is putting SCC online, which is very different from SCR also.
No, so I'll refer it from the
You
SCR.
already stated that you will be referring to it from SCR.
Yes, Malat. So I'm just saying, Malat, because we've marked SCR as per the volume circulated by the nodal officers.
That is what he has already said.
Yes.
So at least when there is no dispute,
Yes.
when he has already said that he will be referring from SCR. Yes.
Lord, I appear for the petitioners in 501.4. Just give me the list. Point 5.
And
1.4. That is my lord Madhukar Singh. 0.5, Durgesh and another.
1 minute.
Then 0.6, 0.7 and 0.17.
Please repeat.
501.4, 0.5, 0.6, 0.7 and 0.17. Now, my lord, these are all persons who were civil judges, and as per the rules, they were not permitted to sit for the direct recruitment exam for district judges. So they filed writ petitions in the High Court, challenging those rules. They got interim orders under which, my lord, they were permitted to sit for the exam. And your lordship may just know, my lord, that 501.4, that Madhukar Singh, he is the topper of the 2014 exam, above all other advocates, etc. He topped that exam. And the petitioner number 2 in the 501.5, what's his name? Krishna Kumar. He is the topper, my lord, of the 2016 exam. These are all in.
Madhukar Singh is topper of?
Lord Madhukar Singh of the 2014 exam. This is in UP. And Krishna Kumar, who's the second petitioner in 501.5, is the topper of the 2016 exam. Just, Lord, by the way, not that anything will turn on the construction.
For 2017, again UP.
Yes, again UP. All these people are from UP, my lord.
Civil Judges Junior Division.
Yes. Now, my lord, the writ petitions were all dismissed on the ground of existing judgments at that time. Satyanarayan Singh, my lord, which is a 1986 judgment, and Deepak Agarwal. And that is how we are before your lordship. Lord, if your lordship straight away has the article 233, because this whole case rests on the construction of the article. And your lordship has, my lord, in 2 orders, named 4 questions of law Your Lordship may just have a look at those questions of law. Order dated 12/8/25, Your Lordship had framed 2 questions, and then the order dated 12/9/25, 2 more questions were framed.
Where are they? 2 questions, Chapman.
There were originally 2, then 2 more were framed.
What are they?
But if in Mr. Datar's submission, my lord, all 4 are together, so that may be relevant. That is, my lord, page 32 of volume 1 of the compilation.
Oh, okay.
That has all the written submissions.
Claim is not that bulky as the earlier CD.
The written submissions are, we've kept them short, my lord, all our written submissions.
Yes.
Page 32, your lordship will find, my lord, where Mr. Datar's submissions start. In para 1.1 are the first 2 questions, whether a judicial officer who has already completed 7 years in bar being recruited for subordinate judicial services would be entitled for appointment as additional district judge against the bar vacancy. So this is somebody, my lord, who already had 7 years before becoming a civil judge. All my clients would not fall under this. They all, my lord, became civil judges before they completed 7 years at the bar. Then 2, whether the eligibility for appointment as a district judge is to be seen only at the time of appointment or at the time of application or both. Then 3, whether there is any eligibility prescribed for a person already in the judicial service of the union or state under Article 233(2) of the Constitution of India for being appointed as district judge. And 4, whether a person who has been civil judge for a period of 7 years or has been an advocate and civil judge for a combined period of 7 years or more than 7 years would be eligible for appointment as district judge under Article 233 of the Constitution of India. All my clients would fall under this category. The 4th category.
7 years of combined experience.
Yes, they all have 7 years of combined experience, including whatever they did as a lawyer before becoming civil judge or as civil judge or including both. Now, my lord, just have a look at the article.
You are concerned with which are these issues?
I'm sorry.
All the 4.
Yes.
According to him,
So,
if he
Lord-
if clause 4 is answered in affirmative, then his client would be
Yes.
Covered by that.
Yes. Yes.
We are in 2 categories. One is covered by question 4, the other is by
Ah,
question.
that's right.
My clients are also in question 1. We have 7 years before being appointed as civil judges. And we say, we don't want any benefit of our service as civil judge. If we are appointed, we will quit and then we will join. So can we be disqualified?
one minute.
Question 4 is.
Question 3 is important.
It says that you concentrate more on question number 4. Because in the event question number 4 is answered in the
All
affirmative,
the others get through.
everybody will get it.
Right. Right.
And first 3, question 3,
It's okay.
eligibility.
Lord, your lordship will have a look at Article 233. It comes under, my lord, Chapter 4 of Part 4. Sorry, Chapter 6
Chapter
of
6.
Part 6, which is the subordinate courts. Part 6 deals with the judiciary. This is subordinate courts. Appointment of district judges. Appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of that state in consultation with the High Court exercising jurisdiction in relation to such state. 2, and we are concerned more with 2. A person not already in the service of the union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. Now, my lord, 2 constructions have been made for this sub-article. Dheeraj Moore, etc., has said that when it says a person not already in the service of the union or the state, it means that he should not be in the service of the state, which according to us, my lord, is completely wrong. The way I read it,
According to you,
yes,
the requirement of 7 years
yes,
would be applicable only to an advocate who is not in service.
correct. Absolutely right. And therefore, my lord, this qualifies or Lord makes two categories of people eligible. One is those already in the,
Advocates and one who are already in the service of the
correct,
union and the
correct.
state.
So those, otherwise, my lord, our submission is that these words, not already in the service of the union or of the state, will become redundant. Your lordship may just look at my written submissions, my lord.
So according to you, then the provision in the constitution
Yes,
would have been that to be eligible to be appointed as a district judge, he has to be an advocate for 7 years.
correct.
That would have been the
Right.
simplicity of the provision in the
If your lordship has, my lord, my written submission, which is page 1 of volume 1, and come to page 5. Page 5, my lord, about 6th line, I have quoted that part, Article 233(2) minus those words which my submission is would become superfluous or redundant if their construction were to be accepted. Now just read it, my lord, as I've taken off those words. A person shall only be eligible to be appointed a district judge if he has been for not less than 7 years and as advocate or pleader and is recommended by the High Court for appointment. This is what would have been sufficient if what they are saying is correct, namely that you have to be an advocate or a pleader. If you are a district judge today, then you cannot, or if you are a civil judge today, then you cannot be eligible. Then, my lord, those words have become completely redundant. So therefore, and it's a well accepted principle of law, that any construction of a statute, or in this case, the constitution,
which
which-
makes the provision redundant.
which makes any words redundant,
Or rather than each and every word
has to have some
given
meaning.
its meaning.
Correct, correct. Now, I have, my lord, I'm relying on 3 judgments for this proposition.
Explain this.
First, my lord, this is in
Person in service is a judicial service.
Yes, that has been clarified by Chandra Mohan, because, my lord, the constitution didn't say it, but Chandra Mohan later qualified by saying, yes, service means
It's a
judicial
judicial
service.
service, yes.
Yes, yes, correct.
Why does it say union? Judicial service, why does it say about it? This is
Because
the state.
there is a historical concept, my lord. As I go along, I'll show your lordship how the history of this, my lord, appointment of district judges happened. That's why it says you.
Revenue officers were also eligible at that time
Correct.
for being elevated.
Correct, my lord. Till Chandra Mohan, all officers, in fact, I'll show your lordship, my lord, the act and the rules earlier, pre-constitution, who was eligible.
That's what was used by. The one says even if it's located in a later article, we use the same definition. What no?
Yes, give me the relevant paragraphs of answer. Paragraphs.
588, page 588.
Para?
281. Internal page 281. Two more. Once
Lord, if your lordship turns to volume 5, sub-volume 2. This is that volume 5 is the case law volume, my lord.
The new one.
It's there, my lord, in the compilation which has been uploaded. Volume 5, sub-volume 2. And this judgment starts at,
Which, Rameshwar?
no, my lord. I'll first only on the point that no words of a provision can be made redundant.
Settle law, but they just.
That's correct, my lord. So just one, very quickly, one paragraph from that judgment. This judgment starts at page 580,
518.
580, my lord, and the relevant part is at 588. I'll just give your lordship the citation of the other two judgments which I am relying on for this proposition. I don't need to show it. As your lordship said, this is a well accepted principle. At page 588, my lord, between placetum D and E, in Quebec Railway,
1 minute. Holy Devi.
yes, Hansoli Devi. And I'm reading, my lord,
1 minute.
page 588, which is 281 of the
Because
report.
that page,
It begins, my lord, at page 580.
5.
80. I'm reading, my lord, page 588. Just one very short 4 lines. Between placetum D and E, in Quebec Railway. Lordship has it. In Quebec Railway, Light Heat and Power Company Limited versus Vandry, it had been observed that the legislature is deemed not to waste its words or to say anything in vain, and a construction which attributes redundancy to the legislature will not be accepted except for compelling reasons. Two other judgments, my lord, which are Rao Shiv Bahadur Singh, 1953, 2 SCC, page 111.
Rao Shivbahadur Singh.
1953, 2 SCC, page 111.
1 minute, 1 minute.
Yes, I'm sorry.
Rao Shivbahadur Singh versus.
Let's take out the name. State of UP.
Are they mentioned in your?
Yes, they're there in the compilation, my lord. Your lordship can take it that they are in volume 51. 51. First and second serial numbers.
Give us the page number
Yes, my lord. The first one is page 2
of the compilation.
of volume 51 of the compilation.
Yes.
And the second one is page 72. The first one, my lord, which is Ashwini Kumar Ghosh, the relevant paragraph is para
The first
26.
one is Rao Shivbahadur Singh or?
First one, my lord, in the compilation is Ashwini Kumar. Paragraph of that is 26. And Rao Shiv Bahadur Singh, which is at page 72 of the compilation, paragraph of that is 10.
Paragraph?
10.
Then, and here para 26. In Ashwini Kumar, para
26, para 26. So therefore, my lord, any.
So you will get n number of judgments on this.
Yeah, correct. Your lordship is right. So,
No word about statute.
right. You can't attribute redundancy to the legislature. Why would they have added those words there? In fact, my lord, the history would make it
Yeah.
clear as to.
Does it become redundant according to you?
Lord, I had given your lordship, my lord, the same 233(2).
That only the advocate having a 7 years practice to accept it. Then the first part, there are a person who is not already in service of state and union. That will be rendered OTO.
More of a clarification according to them. Not OCS, that's what we get. According to them, probably it is only more of a clarificatory. They want one way of exclusive.
If they are saying, that it is only advocates who are eligible, then what is the use of saying, but government servants are not eligible? All sorts of people are not eligible. Why would you specifically lay down government servants are not eligible? Supposing the words that not be already being in the service of the union or the state were not there, and the only words were that a person has to be an advocate for 7 years, that in any case excludes those people not being in the service of the union or the state.
This way, you have to see whether it is clarificatory or not. Certain statute and even the constitution also which says it can combine both exclusion and inclusion.
Exactly.
We have tried to tell you, in the first part it excludes, and other part it includes.
Exactly.
Lord,
That one way, but therefore it will not become redundant that way. How
clarificatory.
to interpret the provision is one thing.
Yes,
To
yes.
say because of that it will become redundant may not be correct.
Lord, clarificatory would only be in a situation where there is any confusion. Now, Lord, in my written submission, I had,
You can very well say.
yes,
Is 233 232 wants to make it doubly clear that the law advocate should have 7 years, while they differentiating between the others. Therefore, this 7 years qualification is not foreseen for them. Therefore, you can apply it that way.
my Lord, construction.
This
of
qualification of
233(2).
7 years meant for only lawyers.
Yes,
And then it may not meant for the other. That may be the one way of argument. Or there are, on the contrary, their argument is going to be, yes, it is only meant for 7 years. In that process, they want to exclude this.
but they would be
It's-
excluded anyway.
Yes, sir.
Supposing, my Lord, just
Only,
have.
only a language, we want to see the ultimate meaning what is conveyed. There is no exclusion per se that way. It's only the understanding of the provision.
First, try to
Yes,
little with them at least read.
Now, my Lord, next I want to take your Lordship to a little bit of, Lord,
Yes.
history. Lord, under the Indian Civil Services Act, where is that page? See volume, eh? If your Lordship has volume 4 of the compilation, this is, my Lord, at page 12 of volume 4 is the Indian Civil Services Act. I'm sorry for the poor print. We couldn't get a better print anywhere. You have that copies of that other thing? If your Lordship has, my Lord, page 12 of that compilation, volume 4, Indian Civil Services Act 1861. Actually, we had a better print, but it didn't have the heading, the Indian Civil Services Act, so it was a little confusing.
Yes.
If your Lordship has, my Lord, on the same page, section 2.
All vacancies happening in any.
Yes, all vacancies happening in any of the offices, places, or employment specified in the schedule annexed to this act, and all such, what is this? Offices, offices which may be created hereafter shall
We filled up.
be filled up and supplied except as hereunder provided from amongst the, what is it? Covenanted civil servants
Among
of the
the-
Crown in India.
Wanted staff, civil services.
From
the
amongst
Crown
the
in-
covenanted civil servants of the Crown in India. So, and if your Lordship has the next page, the schedule under judicial, the posts are civil and sessions judge, which is today the district judge and sessions judge, or chief judicial officers of districts in the provinces now known as regulation provinces, additional and assistant judges in the said provinces. So, my Lord, for these posts, only persons from the civil services could be appointed. That was the position in 1861. So there was no question of any, my Lord, lawyers, etc. It was only from civil services that district judges could be appointed at that stage. Then your Lordship may have, my Lord, the Government of India Act 1915, which is at page 47 of this compilation. it starts a little earlier, but I'm reading, my lord, section 98 and 99, which is at page 47 of the compilation. The lordship has that, my lord? Section 98 at page 47. Subject to the provisions of this act, section 98 I'm reading.
Yes.
Subject to the provisions of this act, all vacancies happening in any of the offices specified or referred to in the third schedule, and I'll just show the third schedule that includes this district judge, etc. And all such offices which may be created hereafter shall be filled from amongst the members of the Indian Civil Service. Then there is a kind of a proviso, that next section, section 99. The authorities in India by whom appointments are made to offices in the Indian Civil Service may appoint to any such office any person of proved merit and ability, domiciled in British India and born in British India, of parents habitually resident in India and not established there for temporary purposes only, although the person so appointed has not been admitted to that service in accordance with the foregoing provisions of this act. So there is a power to appoint people who are not in the Indian Civil Service, and that is to be done by rules, which is 99(2). Every such appointment shall be made subject to such rules as may be prescribed by the Governor General in Council and sanctioned by the Secretary of State in Council with the concurrence of a majority of votes at a meeting of the Council of India. And the third schedule, your lordship will find at page 61. That is that these offices normally from the civil services, but the authorities can appoint from others also as per rules. And these offices include, my lord, at page 61, part 2 of that bottom, offices in the provinces which were known in the year 1861 as regulation provinces. 7, district and sessions judges. 8, additional district or sessions judge and assistant sessions judge. Now the rules are very important, and that is, my lord, at page 100 of this compilation. This is the notification dated 30th March 1922 as amended by notification dated 17th May. Plot that handwritten correction is on the website of the government itself. This is how it is there. Now, Rule 1 says, with the previous sanction of the Governor General in Council and of the Secretary of State in Council and local government may, by notification in the official gazette, declare the number of superior executive and judicial officers being offices ordinarily filled from amongst the members of the Indian Civil Service, to which, subject to the provisions of subsection 1 of section 99 of the Government of India Act, persons not being members of the Indian Civil Service may be appointed. 2. Within the limit of the number declared under Rule 1, the local government may appoint, and your lordship will straight away have Roman 2 because Roman 1 refers to executive office. 2, to a superior judicial office, a member of the provincial civil service, subordinate to the local government, or a person who at the time of the appointment is a barrister of England or Ireland, or a member of the faculty of advocates in Scotland, or B, a vakil, pleader, advocate or attorney of a high court in India, or C, a pleader or advocate of a chief court or of a judicial commissioner's court, or D, a pleader of a district court, etc., etc. So therefore, Lord, 2 streams are very clear. One, that he is a person, a member of the provincial civil service, subordinate to the local government, or a person who is a barrister, vakil, pleader, etc. So this is the history of how Lord 233 has come. Those two streams, namely a person who is a member of the provincial civil service,
But whether the superior judicial service is defined,
that your lordship saw, my lord, in the third schedule to the Act, the Government of India Act 1915. That was, my lord, at page.
it says offices in the provinces which were known in the year 1816 as regulation provinces.
So these are the regulations made under, these are the rules, my lord, made under section 99(2). If your lordship comes back to the Government of India Act 1915.
1992, so which permits even those persons who are not in Indian civil services and who are,
Yes, correct.
who are
correct. So
domiciled
therefore,
to be appointed.
so even at this stage in 1915, 1922, 23, those who were in the civil service could be appointed district
Yes.
judges. But apart from that, those who were in the provincial service or those who were advocates, barristers, vakils, pleaders, etc. That came by way of, my lord, the rules made under this 1915 Act. So that, my lord, the notification of 1923, namely either member of a provincial civil service subordinate to the local government or a person who was a barrister, vakil, pleader, etc., came by this. And that is how, my lord, when the Government of India Act 1935 came, Article 254, which is the precursor to 233 in our constitution, my lord, came, which is more or less the same. Your lordship will have a look at it at page 136 of this compilation. (254) of the Government of India Act 1935. District judges, etc. Appointments of persons to be and the posting and promotion of district judges in any province shall be made by the governor of the province exercising his individual judgment, and the High Court shall be consulted before a recommendation as to the making of any such appointment is submitted to the governor. To a person not already in the service of His Majesty shall only be eligible to be appointed a district judge if he has been for not less than 5 years a barrister, member of the Faculty of Advocates in Scotland, or a pleader, and is recommended by the High Court for appointment. So more or less identical, except that 7 years is 5 years. So this is, my lord, how 233 came pursuant to. So the history of it shows that initially,
The Article 1 and 2
yes,
are drawn from 254, 1 and 2.
yes. And 254 of the Government of India Act, my lord, was from the earlier thing, namely where people from the civil service were, eligible to be appointed. Provincial civil, initially only ICS.
According to even after 1935,
Yes,
the practice of people being appointed from the ICS,
yes,
also from the bar,
yes.
that continued.
That continued, not just the ICS, also from the provincial civil services, from the civil services. So a person not already in the service of His Majesty shall only be eligible. So therefore, my lord, this has been coming from that period, and this is the background in which your lordship has to interpret 233. Why it said a person not already in the service. Namely, a person who is already in the service is eligible anyway. A person not already in the service is eligible if he has been an advocate for 7 years. And that ties in, my lord, with my submission that otherwise it would make those words redundant. Then, my lord, before I take your lordship to Rameshwar Dayal and Chandra Mohan, which are the two most important judgments.
260 of the Constitution debate.
Before I take your lordship to those two very important constitution bench judgments, I want to show, my lord, what happened in the Constituent Assembly debates.
Yes, that is.
Although not very much happened, but there is something relevant. So if your lordship has, my lord, page 259 of this volume 1, that volume 5, volume 4, the same volume that your lordship was reading just now. Page 259. Towards the bottom of the page, the last 7 or 8 lines, Article 209A. Does your lordship have that, my lord? 209A was the draft article which became 233.
One and 9A.
Yes. Does your lordship have that page, my lord, 259?
Yes.
Yeah, I'm sorry. The Honorable Dr. B.R. Ambedkar. Sir, I move that after Article 209 between chapters 7 and 9 of Part 6, the following be inserted. And then 209A is quoted, which is identical to 233. And then, my lord, on the next page, 260, if your lordship has just below the middle of the page, paragraph beginning, sir, the objects. After, my lord, the entire thing is quoted up to 209F, which takes us to, my lord, 237. Just below 209, at page, my lord, 260, the last paragraph, sir, the object. I'm reading that part. Sir, the object of these provisions is twofold. First of all, my lord, the last paragraph on page 260. Sir, the object of these provisions is twofold. First of all, to make provision for the appointment of district judges and subordinate judges and their qualifications. So therefore, my lord, this article provides for qualifications of district judges. Whether now appointment of district judges would include whether it is by way of direct recruitment or promotion. Appointment is to a post there are two ways of getting appointed to that post, either direct recruitment or promotion. So if you are laying down qualifications to be appointed district judge, and that qualification, as my learned friends on the other side would say, is only 7 years an advocate and not being in the service, then, my lord, how can civil judges even be promoted to district judges if the qualification is only, according to them, 7 years an advocate? Because, as your lordship sees, my lord, from these debates, this article is laying down the qualifications as well. And if you limit the qualification, if you take away those in the service, those in the judicial service, which is what we are reading, then, my lord, it leaves only 7 years an advocate. So how can a civil judge even be promoted to district judge? Because then he's not qualified.
You respect, they are not saying so.
I'm sorry, my lord.
Nobody's saying.
Saying so.
Nobody's saying.
They are not saying. They're saying that they are only saying how to reckon the 7 years. That's the only thing. You cannot get to rest. 7 years means only as a lawyer you should be there.
So they are saying that
Promotion day, nobody's
233.2.
saying.
Lord, let's see what they are saying. Just come back to 233.2.
It has to be very clear. They are not making the statement. What they are saying is that.
No, they may not be saying it.
That's no problem.
Because
But
they are saying,
this only
they are saying, my lord, that civil judges are are eligible for promotion. But what I am submitting before your lordship is this: if, as Dr. Ambedkar says, this this entire lot of articles from 209A to 209F, which is 233 to 237, lays down the qualification of district judges, a qualification of persons to be appointed district judges. That qualification is only in 233(2). Nowhere else. None of the other articles says that. Now, how do we read 233(2)? They say that 233(2) is excluding civil judges, and the only qualification that is prescribed is 7 years an advocate. If that is the case, my lord, I ask myself the question, then how do civil judges get promoted? Because that's also an appointment. They cannot get promoted. The object of 233(2) is to lay down the qualifications. No,
Well, let us put their case. Their case is simple. 233 alone you command that. 233(2) is meant for them. It's as simple as that. For that purpose, it makes clear, it excludes the somebody who's in employment of state and civil union. That's the thing.
I'll meet that also. I'll meet that also.
Argument would only be, it is not their argument, therefore we do not blabber much on that.
That would not be the argument.
What they are saying is, for the direct recruitment, the 7 years is only for the lawyers alone. That 7 years qualification, they have been excluded from 233(2), not 233(1).
Therefore, my lord.
233(1) speaks about promotion.
Correct.
It can be done.
So therefore, my lord, according to them, where does the eligibility of civil judges come from under these articles? Because obviously they have to be eligible for being promoted. They have to be eligible for being promoted. Where is that eligibility coming from? According to me, that eligibility is, even if they were to be promoted, for a moment, let us argue against me, my lord, that their only avenue is promotion. Where is that eligibility laid down in Article 233, 234, 235, 236, 237? According to me, there is no other place except 233(2).
233 deals only with the district judges.
Correct?
Then 234 deals with the recruitment of persons other than the judges.
Yes,
It provides for making of the rule.
right. Therefore, are they saying that the eligibility of civil judges to become district judges is coming only by way of the rules? In my humble submission, that's why I referred to, my lord, the Constituent Assembly debates, namely that these articles are providing for the qualifications for being appointed as district judge. And that, in my humble submission, would include the qualifications for being promoted as district judge also, because promotion is also appointment. Appointment is.
Well, word also use promotion. Words used in sub-article 1
Yes.
also use the appointment, posting and promotion.
Yes, yes. So therefore, my lord, your lordship is right. But generally, the appointment includes, in fact, my lord, under the UP Judicial Service rules, your lordship may straight away have that, my lord, the Higher Judicial Service rules. Please have a look at page 419. Same compilation, same volume.
490.
419. This is the UP Higher Judicial Service Rules, 1975. As amended from time to time. This comes under Part 4, Procedure for Direct Recruitment. And your lordship will find Rule 18 at the bottom of page 419 is Procedure of Selection. That is direct recruitment.
Direct recruitment for what?
For district judges. And then your lordship will have on the next page, Part 5, Rule 20, Promotion of Members of the Nyayak Seva, as referred to in Rule 5A. And then, my lord, straight away come to Rule 22 at page 421 bottom. appointment. Subject to the provisions of sub-rule 2, the governor shall, on receipt from the court of the list mentioned in rules 18, 20, and 21, make appointments to the service on occurrence of substantive vacancies. 18 refers to direct recruitment, 20, 21 refer to promotions, all of which comprise appointments. In fact, when a person is promoted to district judge, his promotion order reads as you have been appointed as district judge. नियुक्त किया जाता है.
Try to understand and we'll
Yes.
put it to you how it is.
Lordship, please.
There are two provisions in 233, 1 and 2. One confines to only to the judicial officers on promotion, or even take it for appointment. That does not prescribe any other qualification or eligibility criteria, correct? Now, Rule 33, Section Article 233(2) speaks about the lawyers other than those who are in employment of state or union. So what, in other words, what you are saying is this. Article 233(1) speaks about the appointment for promotion. It includes promotion of a judge who is already on roll.
No, my lord, just read 233(1) with me. It doesn't say civil judge there. That's a general, in fact, my lord, what?
Whatever it may be, we take it.
Right,
We'll take it.
right.
See, perhaps we can appreciate your argument if you say 233(2) is the only article which speaks about eligibility criteria.
Correct. That's what I'm saying.
Therefore,
Right.
that is in common.
Correct, my lord. That's exactly my point.
233,
That's my submission.
233, Article 233(1), we'll put it this way. Article
Yes, yes.
231 does not speak about lawyers, correct?
It does not speak about civil judges as well. That's a general power.
We will not go into that. That's
Correct.
redundant now, irrelevant now.
Correct.
So we are only concerned with the issue between lawyers and the judges
Civil judges.
with
yes.
respect to the direct recruitment. That's
Lordship.
why I said promotion, we will not go into the other things.
Right,
There are
right,
two channels, we
right.
will not go into it.
No, so
So nothing much can be said about 233(1). Where 233(2) it says, it speaks about for the first time about the lawyers. It speaks about, according to you, it speaks about the right of a lawyer to write the examination to be qualified for the direct recruitment. Only to that
right,
time
correct,
alone.
my lord.
In that qualification is fixed at 7 years. So therefore, your argument, as we understand, is that then in 233(1), which does not prohibit the participation of a common servant, or whoever it may be, from being considered for a direct recruitment, this qualification prescribed and under 233(2), ipsa facto will be imported into that. To that extent, we agree. That's
correct.
what. That's
Now, my lord, the only additional point that
Let us not go into the rules because the rules may be different for every state. Let us confine ourselves to the interpretation of the Constitution.
right.
You can't import the provisions of rules to interpret a
In
Constitution.
fact, that's something which, my lord, I completely agree with your lordship, my lord. In fact, that is something, the point of whether you can use rules to interpret a provision of an act or even of the Constitution. I have been looking for law, my lord, on this aspect that the act or the Constitution can be interpreted only directly. You can't use what rule has been framed to interpret that. Otherwise, the position would be
Otherwise,
that you can change a rule and therefore change the meaning of the act or the Constitution.
So let us,
So I have,
let us restrict also to the interpretation of the.
yeah, correct. So therefore, my lord, leave aside the rules for a moment. I am only saying this, that as Dr. Ambedkar said, this article prescribes the
According to
qualification.
you, Article 233 prescribes for appointment, posting and promotion of the district judges.
Yes, my lord.
And
And therefore the qualifications also.
And if the contention is to be accepted,
Yes.
then there can't be one promotion by of a civil judge to the district judge.
No, my lord, I'm not saying that. I'm not saying that a person can't be promoted. Yes, he can be promoted. I am saying something a little different. If this is prescribing the qualification, then where is the only qualification that Article 233, my lord, provides is 7 years an advocate? Or that you are, if I'm correct, then 233(2) also prescribes that or you are in the service, which has been not interpreted to mean the judicial service. So therefore, if you say that I am wrong in saying that 233(2) provides for judicial service and doesn't exclude it, and that if they are right in saying it excludes it, then where is the qualification for civil judges in this article? I am saying that there is no qualification therefore prescribed for civil judges because they can't be 7 years an advocate. I'm using that as an aid to say that therefore 233(2) refers to two streams. One, that either you are in the service of the Union of the States, which means judicial service, or you are an advocate. If you take the construction that they are, my lord, espousing, namely that no, 233(2) excludes those who are in service and includes only those who are 7 years an advocate, then in which case, my lord, civil judges will not be eligible to become district judges, even by promotion, is my submission.
That's what we also put it to you, but in different. We are now only one hour left. So
Yes, I'll finish in 1 hour. I'll finish in 1 hour. Now, my lord, straight away, your lordship will come to those two judgments. Just before that, my lord, Shetty Commission will come to later. Just come to those two judgments. First have Rameshwar Dayal, volume 5(1), page 98. If your lordship, my lord, turns to page 100, that's where the judgment starts. A writ was filed, my lord. This just gives the background facts, and I won't read it, my lord. I'll just tell your lordship what they are saying. A writ was filed challenging the appointment of 5 persons as district judges. That writ was dismissed by the High Court, and the ground taken was, and that's towards the bottom of the page at page 100, that they were not qualified to be appointed as district judges under Article 233 of the Constitution at the time when they were appointed by the state government. And therefore, the appointment as such was constitutionally invalid. Now, the facts, my lord, have been, this, my lord, incidentally, as your lordship might note, my lord, that included the appointment of Justice H.R. Khanna, which your lordship will find at the bottom of page 100.
page 100.
Page 100 of that compilation, at the bottom, your lordship will find that one of those 5 people whose appointments was challenged was also.
Compilation.
I'm volume 5, 1. I'm so sorry. The judgment starts at page 98 of this compilation.
You have also given SCC online. So I think
I have not given that, my lord. I was reading it from the SCR because both these Constitution Bench judgments were pre-SCC.
okay.
So later they have been. SCC started in 69. So anything before that, my lord, was not originally in the SCC. Now SCC has kind of taken those judgments and put it in.
Yes, volume page 100.
Page 100, my lord, the judgment starts, and the background facts were that 5 people were appointed as district judges. Their appointments were challenged on the ground that they were not eligible under 233. Now, I was just, my lord, pointing out just as a matter of interest that one of the 5 was Justice H.R. Khanna, who was District and Sessions Judge, Delhi, who later, my lord, came here, whose portrait hangs in Court 2. Then your lordship will have, my lord, page 100 and the points for consideration at page the 879, if your lordship has. At page 103, your lordship will have the facts of 2 of these people. Paragraph 5 at the bottom. Respondent 6, P.R. Sawhney, was called to the bar on November 17, 1930. He was enrolled as an advocate of the Lahore High Court.
I think the issue was whether the practice at Lahore would be taken into consideration.
That was not the only issue. One of the issues was that they were working in the government at the time of their appointment, and therefore would they be eligible at all? Your lordship is right. That was one of the issues. namely their practice at Lahore, would it count or not? So that would apply to Lord H.R. Khanna, etc.
Yes.
But-
Referring to which volume?
Volume
What I
5,
saw.
sub-volume 1. Volume 5, sub-volume 1. The judgments are in volume 5, my lord. Sub-volume 1 is the very first one of those.
From page to page 401.
So it's like a V1.
VA and VR. Volume VA, VR.
Yes,
I'm so sorry.
105.
103 old.
Yes,
Respondent PR.
yes.
Sawhney.
Was called to the bar on November 17, 1930, was enrolled as an advocate of the Lahore High Court on March 10, 1931. After partition, he shifted to Delhi, worked for some time as legal advisor to the custodian evacuee property. Then he practiced for some time at Delhi. He then accepted service under the Ministry of Rehabilitation as an officer on special duty and administrator Rajpura Township. On March 30, 1949, he became the chairman Jalandhar Improvement Trust. On March 6, 1949, he got his license to practice as an advocate suspended. On April 6, 1957, he was appointed as district and sessions judge while he was, my lord, the chairman of the Jalandhar Improvement Trust. So he was in the service of the union or the state or whatever it was, and he was not an advocate. In fact, he had got his license also suspended and he got appointed. So the question was whether he was eligible or not. Now, also, my lord, at page 103, top paragraph 2, Harbans Singh, he was then the deputy custodian of evacuee property when he was appointed district and sessions judge. So these two people were not lawyers, my lord. They had been lawyers earlier, but were not lawyers at the stage when they got appointed as district judges. Now, if your lordship, my lord, turns to the next page, 104.
Right. Same thing is what with respondent to Urban Singh.
That's right. That's right. That's correct, my lord. He was respondent number 3, Harbans Singh, 103 top.
The question with regard to Justice H.R. Khanna
Yes,
was with regard to whether his practice at Lahore
Right.
could be
correct,
taken into
correct.
consideration.
So that was
for
a separate
completing
question.
the total.
Absolutely right. Absolutely right. So that, my lord, we are not concerned with whether his practice at Lahore. That was, of course, my lord.
Now, after
Now, my lord,
the
at
only
page.
question is whether the service of Sawhney
Yes. And
and
Harbans Singh. Harbans Singh.
as a service in the government,
Yes,
which was not a judicial service,
correct.
could have been taken into consideration or not.
Not taken into consideration. When they were appointed, they were not lawyers. One of them had got his license suspended and they were working there. He was chairman of the Jalandhar Improvement Trust. Question is, are you eligible? And therefore, my lord, the question of the 233(2), either in the service or advocate of 7 years, that question therefore arose. Now just have a look at, my lord, 104(2), 104 about. Your lordship has page 104.
Yes.
About 6th line from the top. Two of them, Harbans Singh and P.R. Sawhney, did not have their names factually on the roll when they were appointed as district judges. Your lordship has that sentence, Vinod?
Which line?
About 8th line or 7th line from the top. Two of them, Harbans Singh and P.R. Sawhney.
PR Sawhney.
Yes. did not have their names factually on the roll when they were appointed as district judges because they were not working in the government.
Government, yeah.
One of them was the chairman of the Improvement Trust. The other person was custodian of evacuee property. Now, my lord, Article 233 is quoted on that page, and immediately after 233(2) has been quoted, now the argument of learned counsel for the appellant has ranged over a wide field, but the point for decision is a narrow one and depends on whether respondents 2 to 6 fulfilled the requirements of clause 2 of Article 233 of the Constitution when they were appointed as district judges by respondent 1. Then your lordship may have, my lord, page 110.
Two and six, they are one part, and
Yeah.
3 and 4, the other part.
Sorry, I'm sorry.
2 and 6, they fall in one category,
Yes,
and 3 and 4, they fall in other category.
right, correct.
3 and 4 with regard to their experience at Lahore,
Yes.
and 2 and 6 as to whether their service can be considered.
I think, Lord, this Harbans Singh was respondent number 3 and 6. The paragraph is,
Urban was number 2.
Lord, if your lordship has page 103, top of the page, respondent 3,
Number
Harbans
3.
Singh.
Respond number 3,
Yes.
Urban Singh.
Now, if your lordship turns to page 110,
Yes.
articles about, my lord, 10 lines from the bottom. Articles 124 and 217 are differently worded and refer to an additional qualification of citizenship, which is not a requirement of Article
You
230.
are at page 108.
110, my lord. I'm so sorry. Because before that, my lord, the discussion is about that Lahore part. We are not concerned with that. Articles 124 and 217 are differently worded and refer to an additional qualification of citizenship, which is not a requirement of Article 233. And we do not think that Clause 2 of Article 233 can be interpreted in the light of explanations added to Article 124 and 217. Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the union or the state, no special qualifications are laid down, and under clause 1, the governor can appoint such a person as a district judge in consultation with the relevant high court. As to a person not already in the service, a qualification is laid down in clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. The clause does not say how that standing must be reckoned, and if an advocate of Punjab High Court, etc., then skip that part, my lord, and then come to the bottom of page 111. We now turn to the other two respondents, Harbans Singh and P.R. Sawhney, whose names were not factually on the roll of advocates at the time they were appointed as district judges. What is their position? We consider that they also fulfilled the requirement of Article 233 of the Constitution. Harbans Singh was in the service of the state at the time of his appointment, and Mr. Vishwanath Shastri, appearing for him, has submitted that clause 2 of Article 233 did not apply. So therefore, if he was in the service, then itself he is eligible. And this was a direct recruitment, not a promotion. So that is one ground that is given by the Constitution bench. The other ground is the next sentence. We consider that even if we proceed on the footing that both these persons were recruited from the bar and their appointment has to be tested by the requirements of clause 2, we must hold that they fulfilled those requirements. They were advocates enrolled in the Lahore High Court, etc., and that their practice of 7 years would be counted. So the two grounds are given. One, that because they were in the service, therefore they fulfilled it. Because, my lord, 233(2) was read in the manner in which I am reading it. Namely, that two kinds of people are eligible. One, that those who are already in the service, and two, advocates of 7 years. So both the reasonings have been given in this judgment to make them qualify, to not set aside their appointments. Number one, since they were in the service, they qualified. And number two, in any case, their prior experience.
No, but then, even though they were not in the judicial services.
Correct, because that lord came only by way of Chandra Mohan.
Chandra Mohan.
Yeah, that came only later, because till then your lordship saw.
But then what is most important to you?
Yes.
Is observations in page 110, last 7, 8 lines.
Yes. Yes. Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the union or the state, no special qualifications are laid down. Absolutely right, Manoj. Absolutely right.
But how does Dheeraj More distinguish this?
I'll show your lordship, my lord. It just says, no, this is something totally different. I don't know how it's been distinguished. Chandra Mohan is even clearer. I'll show to your lordship Chandra Mohan.
Let us go to Chandra Mohan.
Yes, straight away, my lord. Now, Chandra Mohan is, my lord,
Because these are 5 judges.
both of them are 5 judges.
This was also 5 judges.
This is also 5 judges. Chandra Mohan is also 5 judges. Both were binding, my lord, on Dheeraj Mohan.
Binding on Dheeraj More.
Yes, absolutely right. Page 180, my lord, of the very same compilation, your lordship will find Chandra Mohan. If your lordship turns to page 183, that's where the judgment starts. I'll just read that first paragraph, my lord, because there is a phrase called judicial officers who are actually from the executive department. That has created a bit of a confusion. In Dheeraj More, they say that this part goes against you because they hold that these judicial officers were not qualified. Judicial officers here, they state in this paragraph, was a euphemism used for those in the executive service. I'm reading, my lord, between placetum C and D on page 183. The facts may be briefly stated. During the years 1961 and 1962, the Registrar of the Allahabad High Court called for applications for recruitment to 10 vacancies in the UP Higher Judicial Services from barristers, advocates, vakils, and pleaders of more than 7 years standing, and from judicial officers. The expression judicial officers is a euphemism for the members of the executive department to discharge some revenue and magisterial duties. Selection committee constituted, etc. Then, my lord, between placetum E and F, respondents 2, 3, and 4 were advocates, respondents 5, 6, and 7 were judicial officers. Then, my lord, at placetum G, thereafter the appellant who belongs to the UP Civil Services Judicial Branch, who was at the time acting as district judge, and others who were similarly situated as the appellant, filed petitions on the High Court at Allahabad under 226 for an appropriate writ directing the government not to make the appointments to the UP Higher Judicial Service pursuant to the said selection. So he didn't say that appoint me or that I was eligible or that I should have been permitted to sit in the exam. He only challenged the appointments of those persons. Then your lordship may have, my lord, 2 pages later at page 185. Placetum C, the argument of learned counsel for the appellant may be placed conveniently under the following 5 heads. 1. While under Article 233(1) of the Constitution, the governor has to make appointment of persons to be and the posting and promotions of district judges in consultation with the High Court concerned under the rules made by the governor under Article 309 of the Constitution. He has to consult before making such appointments a selection committee constituted thereunder, and therefore the appointments made in consultation with 2 authorities instead of 1 as provided by the Constitution were illegal. 2, on a fair reading of the provision of the rules, it is manifest that the High Court is a transmitting authority, etc. Just leave that, my lord, for the sake of time. Just come to 3.
The governor has no power.
The governor has no power to appoint district judges from judicial officers as they are not members of the judicial service. The exclusion of the members of the judicial service in the matter of direct recruitment offends Articles 14 and 16 of the Constitution, or alternatively, the exclusion of members of the judicial service in the matter of direct recruitment to the post of district judges while permitting judicial officers to be so recruited offends the said article. Then, my lord, your lordship will have page 189. Placetum F. The third point. The third point raised is one of far-reaching importance. Can the governor, after the Constitution, directly appoint persons from a service other than a judicial service as district judges in consultation with the High Court? Can he appoint judicial officers as district judges? The expression judicial officers is a misleading one. It is common case that they belong to the executive branch of the government, though they perform certain revenue and magisterial functions. The relevant article on which both parties rely is Article 233, then that is quoted. Then your lordship will have the next page, While the learned counsel for the appellant contends that the said article must be read along with the group of articles embodied in Chapter 6 of Part 6 of the Constitution and also in the background of the history of the said provisions, and that if so read, it would be clear that the governor can only appoint district judges either from the judicial service or from the bar. The learned counsel for the respondents, on the other hand, argues that Article 233 is expressed in general terms and there is no warrant to restrict the scope of the said article by construction or otherwise. Then your lordship will have, my lord, 2 pages later, page 192, after, my lord, the various other articles in that same part are quoted.
No, you can read to the third paragraph also, that is also important.
Which one? I'm sorry.
Page 190,
190. Yes.
before construing the said provision.
Before construing the said provisions, it should be remembered that the fundamental rule of interpretation is the same whether one construes the provisions of the Constitution or an Act of Parliament, namely that the court will have to find out the expressed intention from the words of the Constitution or the Act, as the case may be. But if, however, two constructions are possible, then the court must adopt that which will ensure smooth and harmonious working of the Constitution and eschew the other which will lead to absurdity or give rise to practical inconvenience or make well-established provisions of existing law nugatory. Grateful. Then, my lord, may I take your lordship to 192? After that whole chapter in the Constitution is quoted, third line, top of the page. Page 192, third line from the top. The gist of the said provisions may be stated thus. Appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state. There are two sources of recruitment, namely one, service of the union or the state, and two, members of the bar. Please mark this, my lord. Two sources of recruitment. The said judges from the first source are appointed in consultation with the High Court, and those from the second source are appointed on the recommendation of the High Court. The article doesn't say that the first source will be only by way of promotion. That will be in consultation, because under
That may be their argument.
and that it is only by way of promotion. That is only their argument, and somehow it is not there anywhere in the article, but somehow it has come from somewhere. But in the case of appointments of persons to the judicial service other than as district judges, they will be made by the governor of the state in accordance with the rules framed by him in consultation with the High Court and the Public Service Commission. But the High Court has control over all district courts and courts subordinate thereto, subject to certain prescribed limitations. So far, there is no dispute. But the real conflict rests on the question whether the governor can appoint as district judges persons from services other than the judicial service. That is to say, can he appoint a person who is in the police, excise, revenue, or such other service as a district judge? The acceptance of this position would take us back to the pre-independence days, and that too in the conditions prevailing in the princely states. In the princely states, one used to come across appointments to the judicial service from police and other departments. This would also cut across the well-knit scheme of the Constitution and the principle underlying it, namely the judiciary shall be an independent service. Doubtless, if Article 233(1) stood alone, it may be argued that the governor may appoint any person as a district judge, whether legally qualified or not, if he belongs to any service under the state. But Article 233(1) is nothing more than a declaration of the general power of the governor in the matter of appointment of district judges. It does not lay down the qualifications of the candidates to be appointed or denote the sources from which the recruitment has to be made. But the sources of recruitment are indicated in clause 2 thereof. Under clause 2 of Article 233, two sources are given, namely one, persons in the service of the union of the state, and two, advocate or pleader. Now, this is not just pausing here for a moment. They are interpreting 233(2), that under 233(2), two sources are given. One is persons in the service and the other is advocate or pleader. And yet, my Lord, Dheeraj Moore says ki no, 233(2) excludes those in service. Completely contrary to this. It does not lay down the qualification. But sources of recruitment are indicated, namely one, persons in the service, and two, advocate or pleader. Can it be said that in the context of Chapter 6 of Part 6 of the Constitution, the service of the Union of the state means any service of the Union or of the state, or does it mean the judicial service of the Union or the state? The setting, that is the chapter dealing with subordinate courts in which the expression the service appears, indicates that the service mentioned therein is the service pertaining to courts. That apart, Article 236B defines the expression judicial service to mean a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. If this definition, instead of appearing in Article 236, is placed as a clause before Article 233(2), there cannot be any dispute that the service in Article 233(2) can only mean the judicial service. Namely, judicial service is included in Article 233(2). The circumstances that the definition of judicial service finds a place in the subsequent article does not necessarily lead to a contrary conclusion. The fact that in Article 233(2) the expression the service is used, whereas in Article 234 and 235 the expression judicial service is found, is not decisive of the question whether the expression the service in Article 233(2) must be something other than the judicial service. For the entire chapter is dealing with judicial service. The definition is exhaustive, etc. Then your lordship will have just above placetum D, having defined judicial service in exclusive terms, having provided for appointments to that service, and having entrusted the control of the said service to the care of the High Court, the makers of the Constitution have not conferred a blanket power on the governor to appoint any person from any service as a district judge. Reliance is placed upon the decision of this court in Rameshwar Dayal in support of the contention that the service in Article 233(2) means any service under the state. The question in that case was whether a person whose name was in the roll of advocates of East Punjab High Court could be appointed as a district judge. In the course of the judgment, Justice S.K. Das, speaking for the court, observed, Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the Union of the state, no special qualifications are laid down. And under Clause 1, the governor can appoint such a person as a district judge in consultation with the relevant High Court. As to a person not already in service, a qualification is laid down in Clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. This passage is nothing more than a summary of the relevant provisions. The question whether the service in Article 233(2),
as a matter of fact, they depart from the view taken in Rameshwar Dayal. So,
to the extent, yeah, your lordship is right, because that's
says that any service.
right, because my lord, they had cleared people who were not in the judicial service, namely those two.
That was the situation then.
Correct.
Now.
That is correct. Your lordship is absolutely right. As a matter of fact, they depart slightly to limit it to.
This is under the Constitution scheme.
They raise their foundation on the doctrine of
Yes.
separation of powers
Yes.
and independence of judiciary.
Correct.
Yes.
Correct. But one thing is clear from both the judgments, that 233(2) includes both these streams. Both the judgments say it. And as your lordship rightly asked, my lord, how did Dheeraj Moore come to the conclusion that no, it's an exclusion rather than an inclusion? Then, my lord,
Stream is something which is created by us, not under the Constitution. The Constitution merely says promotion and then direct recruitment, that's all. Qualification is the time, and obviously lawyers cannot be considered for promotion because they are not working as judicial officers. There is no exclusion of judicial officer under 232.
yes.
I mean, if it is recruitment is there, expressly.
Then, my lord, that fourth question, can people in the judicial service be excluded? Your lordship had seen questions 3 and 4 were relevant. So 3 they answer by saying that no, this has to be only the judicial service, not the executive service, not any other service. And 4 they leave open. They don't answer that at all. Can they be excluded? That your lordship will find, my lord, at page 195. The small 2-line paragraph between placetum C and D. In this view, it's not necessary to express our view on the last 2 questions. But naturally, the corollary of what they have held would be that you cannot exclude the judicial service. If there are 2 streams, one is the service, which means judicial service, and the other is advocates. In fact, I'll come to that in a moment, my lord. And that is the next issue that I need to address before your lordship. So therefore, my lord, on the first point,
Can't see. वो जो हो रहा है करें.
Now, Lord, so therefore, in my humble submission, I have finished with the point of whether 233(2) includes that second stream.
According to the 233, who includes both the streams.
Yes,
And the finding of Jurors More,
is
that
completely wrong.
233(2) is exclusively
Yes.
for the members of the bar,
Now, Lord,
is not correct.
correct.
In
Now,
other words, we'll try to actually understand the argument.
yes,
233, 1 and 2, they speak about, they don't distinguish between the promotion and other things. So therefore, qualification is in 233.
Lordship, yes.
And then 233, one it generally speaks about who is the authority to do it, whether it is promotion or a recruitment or appointment.
Correct, correct.
These are all general.
Right.
Governor in consultation with this. And then second thing, it only specifies the qualification of the lawyer. Therefore, you have to read 1 and 2 together.
Absolutely.
One does not restrict only to the judicial
very-
officer, and therefore 2 does not restrict to the lawyers.
Correct.
They both will have to be written in consonant.
Right, right. That's exactly, Lord, how the two constitutional benches.
Lawyers cannot get into obviously promotion.
Correct,
There's no bar for them to come under that.
Right.
Because there is no express exclusion.
right, right. Now, Lord, that leads me to the next question, which is, supposing the Constitution provides for these two sources, can by rules, can you exclude one source completely from direct recruitments? And that immediately raises, my lord, the Article 14 question. Now, in this context, please note, my lord, that all the judgments which have dismissed the Article 14 argument base it on their Lord finding of 233(2) itself excludes those in judicial service in direct recruitment, and therefore you're not eligible. Therefore, there's no question of Article 14. None of them has gone to the extent of saying, no, there are two sources, but one can be completely excluded. So the Article 14 question is very, very Lord clear. If there are two sources provided for by the Constitution, according to me, Lord, one, you cannot just shut out one. Then you are doing something contrary to what
Volume 5 to PDF 72. It's showing Shetty Commission first. It's volume.
So therefore, my lord, my submission on this is, if the
Which are, whether the rules framed by the state governments in consultation with the High Court provide for exclusive bar members.
yes, it does, my lord. Your lordship will have a look at volume 4. We have the UP rules. Just have a look at page 415, Rule 5.
Page,
Volume 4, page 415. This is the UP rules, my lord.
UP Higher Judicial Service.
Yes. UP Higher Judicial Service Rules 1975. And if your lordship turns to page 415, Rule 5, under Part 3, recruitment.
Yes.
sources of recruitment. The recruitment to the service shall be A, by promotion from amongst the civil judges, senior division on the basis of principle of merit cum seniority and passing a suitability test. B, by promotion strictly on the basis of merit through limited competitive examination of civil judges, senior division, having not less than 5 years qualifying service, which your lordship has directed to reduce it to 3 years. And C, by direct recruitment from amongst the advocates who have been not less than 7 years practicing as an advocate on as on the last date fixed for the submission of application forms. So direct recruitment only from advocates. For civil judges, only promotion and this limited departmental comparative exam. You are excluded from direct recruitment.
Amounts to reservation.
I'm sorry, my lord.
Amounts to reservation.
Yes, amounts to reservation in favor of the advocates. So now the question is, can such a rule be, my lord, supposing your lordship holds that 233(2) does not exclude civil judges, persons already in the judicial service. In fact, it includes them. Can the rules exclude them completely? That direct recruitment will be only, my lord, of advocates. In my humble submission, no. That would be doing, my lord, violence to the language of the Constitution and the intention of the Constitution makers. The promotion or that limited direct departmental comparative examination is not a substitute, because that, as your lordship has noticed in that
In any
recent
case, both
judgment.
these constitutional bench judgments,
Yes,
they deal with the direct appointment.
yes, correct. They were not promotions. They are not saying, they were both dealing with.
Therefore, they did not say that you are not even qualified. See, if the question of qualification is there, there's no need to discuss that.
Right.
Yeah, that is the issue. The problem is
Your lordship
that,
is right, but
problem is that, we see, by the order of the
ultimately-
court, they
ultimately-
created two channels.
ultimately,
And
my
we
lord,
try to understand the constitutional mandate through that, through those channels.
correct.
That's the
But-
problem.
Not two, three channels.
Three channels, yeah, three channels.
but
Yeah,
my lord,
yeah,
somebody will have to strike down the rule. The rule is excluding us. Once your lordship holds that no, the Constitution permits, then according to me, the answer is very clear. Then the rule is wrong, excluding us completely. Because till the rule is set aside, that rule still remains and still excludes us. Therefore, my lord, that was our prayer in the writ petition, namely set aside this rule which excludes us. That will ultimately have to be allowed. So I'm just very briefly addressing your lordship on that. Now, my lord, I want to show your lordship the Shetty Commission report. Same volume, volume 4.
Till we create the different modes of recruitment,
Yes,
as you rightly said, there's only one way.
yes,
Somebody to be appointed as a district judge. Supposing it comes by promotion, the others will not have any grievance. It can be regulated only under that. Now, earlier what was there, that the district judge is separate appointment. So they said, who are all qualified to be appointed? There is only one mode. So which means, the judges also be eligible. And then those who are lawyers who complete the 5 years, become eligible. That's only one matter of recruitment. To that extent, that the other point of there was one issue. Once we created the subcategory, that's
that's
the
correct.
said,
The
one through a limited company examination,
In
one
fact, the-
one channel, small channel.
Your lordship is
Then
right.
then it is to give promotion. Then we are trying to understand the mandate of the Article 233 in the light of the factual scenario. That creates a lot of other issues.
Absolutely right, my lord. In fact, that's my case. That what they are saying, one of the arguments that they make is, ki look, under the rules, 75% of the posts are in any case reserved for civil judges, 50% by promotion, 25% by way of this limited departmental comparative exam, and only 25% are left for lawyers. Therefore, that must be upheld. But that's not putting the cart before the horse. Namely, you are saying that you must look at the rules to interpret the Constitution. That can't be. And my lord, yesterday, for the first time, I found a direct judgment on that subordinate legislation cannot be used to interpret, my lord, a provision of the Act. Otherwise, by changing the subordinate legislation, you can change the meaning of the Act. That can't be. Subordinate legislation is made not by Parliament, is made by the government, etc. How can the meaning of the Act, or in this case, the Constitution, change by looking at the rules? Therefore, namely, my lord, if the Constitution says that both these streams are eligible for direct recruitment, then you can't exclude one. That has all been done on a misunderstanding of what the Constitution says, and, my lord, justified by various courts, including some judgments of our court, including Dheeraj Moore, by thinking that 233(2) actually is a negative. This thing that that if you are a civil judge, then you are not eligible. That's what the article says.
Exclusively reserved for the bar judges.
Yes.
Yes.
Now, I was showing your lordship, my lord, the Shetty Commission report. And if your lordship straight away turns to page 656 of this volume 4, where does it start? Starts at 649. Yeah. The relevant portion starts at 656. And I'll just read some parts of it. Because, my lord, the Shetty Commission came to the conclusion that this kind of thing, that you are not eligible to sit for the direct recruitment, is creating a lot of frustration and a lot of stagnation among civil judges. And this is something that your lordship has recently noted, that the reason why we are getting not very good people for appointment as civil judges is because they feel that they get completely stagnated. I get into the service and then now for 15, 16 years, I will not even become a district judge. Your lordship has noticed, my lord, those.
We should notice in that matter.
Yes, yes. No, so last week your lordship has issued notice, but before that your lordship noticed where your lordship has said that senior division should be the requirement of 5 years and senior division should be reduced to 3 years. Your lordship has noticed in that, my lord, in one part of the judgment, how long it takes to even become a district judge for civil judges. Sometimes in some states up to 15, 16 years.
Later when I was also telling the Honorable Chief, one of my law clerk back there in my High Court, I persuaded to accept the civil judge unit division. She's a topper. Last time she met me, then she said, I want to resign.
Yeah, correct.
Where do I end? See, these are aspirations of the young mind. So,
and
what extent we can curtail their.
Correct. And if your lordship were to hold.
Unfortunately, many of the brilliant candidates who join us with the senior divisions, they don't even reach up to the principal district judge.
Yeah.
Yes.
They have to retire they get stagnated as district judges for years together.
Correct. And some of them are, I mean, one of these people who.
So we have to look at it not from their point of view also, from the point of view of the institution and the concept of basic structure.
Yeah.
The idea is to give a qualitative service from the judicial officers. If it does not facilitate it, then you have to take, it will be a contrary to the constitutional mandate.
Absolutely right. If you tell
You
people
have
that
to
if you are
make
accepting.
the bottom of pristine quality, and then you have to take it forward.
Correct.
But if you make it much weaker, then it will justify the structure and keep going in appeal, revision, further appeal, SLPs.
Absolutely right.
This is the
If
problem.
your lordship were to hold, my lord, that 233(2) for this direct recruitment of higher judicial service, it would encourage so many more people to take the civil judges exam, because then they won't feel like once we are in here, it will take us 15, 16 years to become district judges. We are excluded.
They will not come. So
Yes.
how do we encourage our juniors to take this examination?
Correct.
So he is saying that if you answer that question in their favor, then it.
That's right. Absolutely right, my lord. Because if right now they have the feeling, look, if I take this, I'm stuck. I can't sit for the higher judicial service exam. I can only go by promotion or limited departmental. And sometimes that you becoming eligible for that limited departmental comparative examination comes after, my lord, the date where you can be considered for promotion. And very often it takes about 14, 15 years. Whereas if this was permissible, then within 3 years they become civil judge, another 4 years where they'll have a combined experience of 7 years, at least they can sit for the exam.
So that you are agreeable. So even in the event.
But I am agreeable. I am agreeable, although, my lord, the constitution doesn't say so, but I feel that your lordship can lay down, because after all, there has to be a certain amount of experience that a person must possess for being. If you must have 7 years as a lawyer, you must also have 7 years as a civil judge, or combined experience of lawyer plus civil judge.
What about age? So then, if for direct district judges, age is prescribed as 35, then if you are permitted to join it prior to that, it will not be discriminatory towards the members of the bar.
It,
It's a gender restriction.
it should be so long as.
Goes along with, see now, even for the lawyers also, age restriction is there.
That's what.
That gender restriction will be there. Age has to be.
It is another requirement. Age is another requirement.
Civil judges, I don't think there's an Article 14 issue. And my lord, that is something that your lordship may, that is something that your lordship may consider whether it should be lowered for both the categories, namely for lawyers also and for civil judges also, as to whether they would be more encouraged to take civil judgeship or even district, the higher judicial service exam if it was less.
They put a state barrier because they cannot go outside the state. So only 5 minutes.
I was showing you, Lordship, my lord, the Shetty Commission recommendations. They realized that, look, this is a huge point of frustration for civil judges, and recommended that they should be permitted to take the higher judicial service exam, because till then, my lord, it had become a sort of a established norm that they were excluded. So Shetty Commission said this, but unfortunately, my lord, when the Shetty Commission came to court in that All India Judicial Services, that judgment, this part was neither noticed nor rejected nor accepted. So I'm just showing to you, Lordship, my lord, at page 656, conclusion, just below Article 233(2), about middle of the page, conclusion, 11.50.
6.5?
656 of volume 4.
Yes.
Volume 4 has all those historical documents, my lord. We have given our anxious consideration to the views and comments expressed by the respondents to our questions 8.3 and 8.4. The majority of the high courts and the service associations, barring a couple of them, are for giving an opportunity to the service judges for direct recruitment of district judges. Even some of the governments are in favor of such a move. The reasons given in support of the proposal are that it would promote efficiency, improve discipline in judicial service, and make the officers to work more efficiently, diligently, and sincerely. We are highly impressed by the reasons given by the High Courts of Allahabad, Bombay, Punjab and Haryana and the All India Judges Association. If meritorious young blood should be introduced in the mixed cadre, there is no reason why merited serving judges should be excluded from consideration for direct recruitment. In such selection, the High Court will have an opportunity to assess their merit, the merit of serving judges as against the merits of the competent advocates. The Bombay High Court has rightly observed that the High Court in such selection will have an added advantage of assessing the service judges on the basis of their work and confidential records. So, the next page also, my lords, up to about 11.58 are the relevant parts of the Shetty Commission report. I know, my lord, I'm running out of time. That's why I'm just
No, you tell us what are the paragraphs which are relevant to them.
up to, my lord, from 11.50 up to 11.58.
We have eaten into your time in between.
No, Lord. That is part of my time, my lord.
Finish it in 3 days. No?
That is always part of the lawyer's time. Your lordship's questions are most welcome, my lord. That helps us to.
Unless your lordship, it's not fruitful. I was saying,
Mostly what everybody would be doing is saying that we will not repeat anything but repeating the same argument.
we will try not to do it.
Or you have an experience, I have an experience of more than 6 years now.
Which of
the interpretation of the
hotel. Lord, just one judgment I want your lordship to see. That is Hotel Balaji. Where is that?
Balaji.
Hmm? Volume 7.
This 233A and B,
Yes.
1 and 2.
Yes.
You mean to say in 2, if a person is having 7 years of service, then he's eligible.
No. According to him, he should have a combined experience of 7 years.
7 years service or combined experience as a lawyer and a service.
Although, my
Or,
lord,
or if he is a lawyer, then minimum 7 years as a lawyer.
So these 3 propositions.
yeah,
here.
correct. Although, my lord,
Please stop there. Because under 217 also,
yes,
10 years service,
yes,
10 years as a lawyer,
yes,
and suppose somebody is a judge for 9 years and he resigns. He's a lawyer, he's a lawyer for 1 year, then the 9 years experience has to be included.
correct. That explanation double A.
Yes, sir.
Absolutely right, my lord.
Double A.
Yes, explanation double A.
Even if he is a lawyer even for a day,
Yeah, so
and if completes 10 years, then he's eligible.
correct. Absolutely right. Of course, my lord, I'm not saying that this 7 years of either lawyer or lawyer
No,
plus
my
judge.
learned brother is
I know, my lord, I know.
saying that if a judicial
That-
officer,
that
because
should
we have had instances of persons reaching up to this code also, who are judicial officers and then also district judge and then high court judge. So he said that for being appointed as a high court judge, if you are in service for 9 years and then only a lawyer for 1 year, then your 9 years experience gets counted as a 10 years lawyer. So why not that analogy here?
Right. Now, Lord, I was just explaining that, and I'm grateful for your Lordship's observation, but I'm just saying that that requirement of 7 years as civil judge would not come from the Constitution. If your Lordship just comes back to 233, that would come from your Lordship's, my Lord, Article 142 powers, namely, as your Lordship has done recently, that lay down that.
So it can be, by applying the principle of harmonious constitution, also it can be said
Although-
that if the constitution requires a 7 years experience as a lawyer,
Correct.
then by same analogy, a person who is not having 7 years combined experience as
I
a lawyer,
agree.
or
I agree, my Lord, but that
Yes.
that explanation
there's a lot
double
of debate on 142 now.
that explanation double A would be relevant only if the article had actually said that even as civil judge, you need to have 7 years. So therefore, there the hybrid, etc., would come into play. But my lord, 233 doesn't say anything about the experience as a civil judge. It only says
That we will have to read.
that your lordship can read into it. Yes, whether 142 or whether your lordship reads
Subject to
it.
hearing them, otherwise they will say that.
हाँ, now just कहाँ है वो होटल वाले?
So you see,
इसमें मेरे केस लॉ में है ना? Lord, just one judgment I want to read on the aspect of that you can't use subordinate legislation to interpret the.
is there any judgment necessary on that proposition?
No, quite, but your lordship must pronounce that judgment because, my lord, I'll tell your lordship why. I have been using this argument in several cases because it's an obvious proposition in my mind. Namely, how can you use the rule to interpret a provision of an act?
The rules and the statute.
Supposing there is no
will
conflict.
go away.
Supposing
There is a conflict between a constitutional provision and the statutory provision.
that's Kelson's pure theory of law, but that's a slightly different plot. Supposing there is no conflict, can you use a rule to say this is what the act means? And according to me, you can't, for the simple reason that otherwise by amending the rule, can you say that, all right, now the act means something different? The act, what it means will have to be seen on its own. The rule can't change the meaning of the act. And I had been, my lord.
Yes, please tell us.
Volume 7, page 4240. Volume 57, no? Sorry, volume 57. Roman 57, page 4240. This is 1993, supplement 4 SCC, 536. After having looked for it for several years, my lord, one of my juniors found it yesterday.
He deserves compliment.
What is the law laid down?
The law laid down is, my lord, if your lordship has para 17 and then 31 and 32. 4257 is para 17.
Hotel Balaji and others.
Yes. Because very often, my lord, in high courts, we find judges using rules to interpret provisions of the act. It's a reasonably common, my lord, mistake. That's why I'm saying that your lordship must at least lay down in this that no, you can't do that. So now, my lord, Placitum F on page 17.
4257.
4257.
Para 17.
That's the submission and then two paragraphs, my lord, of the finding.
At page
4257, my lord, is the submission and the finding is at page
4262.
4262.
Para 31. At the
Paras 31 and 32.
read country.
Yeah, I'll just read, my lord,
one way.
the finding. Go to 62.
4262.
31.
31.
Yes.
If your lordship comes to page 4262, para 31, and I'll start at Placitum E.
Four two six two.
Yes,
Placidum E.
para 31.
The argument raises.
This argument raises in turn the question, how far is it permissible to refer to the rules made under an act while judging the legislative competence of a legislature to enact the particular provision? The necessity and significance of the delegated legislation is well accepted and needs no elaboration at our hands. Even so, it is well to remind ourselves that rules represent subordinate legislation. They cannot travel beyond the purview of the act. Where the act says that the rules on being made shall be deemed as if enacted in this act, the position may be different. It is not necessary to express any definite opinion in this aspect for the purpose of this case. But where the act does not say so, the rules do not become a part of the act. Sri Mehta relies upon the following statement of law in Halsbury's Laws of England, 3rd edition at page 401. Consideration of subordinate legislation as aid to construction. Where a statute provides that subordinate legislation made under it is to have effect as if enacted in the statute, such legislation may be referred to for the purpose of construing a provision in the statute itself. Where a statute does not contain a provision and does not confer any power to modify the application of the statute by subordinate legislation, it is clear that subordinate legislation made under the statute cannot alter or vary the meaning of the statute itself, where it is unambiguous, and it is doubtful whether such legislation can be referred to for the purpose of construing an expression in the statute, even if the meaning of the expression is ambiguous. He says that this statement of law has been referred to with approval by Justice Hegde in his opinion in J.K. Steel Limited versus Union of India. Though in the opinion of Justice Hegde is a dissenting one, he submits the majority is not held to the contrary on this aspect. He also relies upon English decisions referred to in the opinion of Justice Hegde and points out that no decision of this court has expressed any opinion on the subject, a fact noted by Justice Hegde. He commends the view taken by Justice Hegde for our acceptance. Sri Mehta points out that further Section 86, which confers the rule-making power upon the government, does not say that the rules when made shall be treated as if enacted in the act. Being a rule made by the government, he says, Rule 42E can be deleted, amended, modified at any time. In such situation, the legislative competence of a legislature to enact a particular provision in the act cannot be made to depend upon the rule or rules, as the case may be, obtaining at a given point of time, he submits. We are inclined to agree with learned counsel. His submission appears to represent the correct principle in matters where the legislative competence of a legislature. So, of course, this was about legislative competence, but even when you are construing the provision.
you can't if you are considering a statutory provision,
Right.
it can't be construed on a both. So this was with regard to whether the rules could be read as a statute.
Yes.
So for that, if there is a substantive provision in the statute that the rules will have to be read as a part of a statute, then it's a different matter.
Right.
If
Absolutely.
the statute does not provide for that, then the rules are always subordinate to the
Correct.
statute.
And any change in the rules can't change the meaning of the act.
And statute would always be subordinate to the constitution.
Correct.
So you can't read a statutory provision
Correct.
to interpret a constitutional provision.
Right. Absolutely right. And so, and here they are trying to read rules to interpret a constitutional provision. I mean, two steps high.
We are yet to
I'm
put-
very grateful to Lordship.
Thank you. In spite of our eating up on your time, you completed it.
Lord, there was some, I would have distinguished their judgments, but Lord, since for paucity of time, according to me, Lord, they are totally contrary to those two judgments, totally.
In any case, there are only 2 5 judges, constitution bench judges.
That's right.
The other, if there are 2 or 3 judges judgments, they may not bind us.
Absolutely right. Absolutely right.
Dheeraj Mori is also 3.
Yes.
Yes, Mr. Datta.
My submissions are in a very narrow scope. The Lordship sees my
You
written
are in
submission.
which number?
Yes, I'm in SLP 3076.
You can give the item number.
501.28.
0.28.
Yes, but my submissions are very limited.
You can just tell us, you are a
Yes, in simple
judicial
terms,
officer.
I was a lawyer. I practiced for 9 years. Then, my lord, I joined the judicial service.
Practice for 9 years.
I practiced, my lordship, just take my written submissions. The chart is there. It'll be easier, my lord. Take my written submissions. Starts at page 32.
Written submission. Mr. Bhushan started his argument with your submission.
Pardon me?
So Bhushan started your argument with your submissions because your submissions only contain all the 4
Yes.
questions.
In fact, I'm going to request your lordship that I'm asking 2 more questions to be taken because the focus of my submissions is that para 45 of Dheeraj More requires reconsideration. That is the short submission I'm making. Because in para 45 of Dheeraj More, they've added 3 new conditions into Article 233(2), which I'm submitting requires reconsideration at your lordship's hands. That's the
But
problem.
if we answer question number 4
Yes.
in the affirmative,
Lord, what my submission is, but still, even if your lordship answers question number 4, the para 45 will still be a law under Article 141, because what the court has said, 7 years means 7 years continuous up to the cutoff date. So, Lord, there is a question as to whether what's the meaning of the word immediate past. So ultimately what Dheeraj More says is, suppose tomorrow I appear, I'm going to apply for the post of a district judge, I write the exam. Then on the cutoff date, that is the date of the application, I should be 7 years in continuous service on the date of my application. It goes on to say I should also be 7 years on my date of appointment. That's the problem.
on the rate of appointment also.
Also. So that is the problem.
So suppose if you appear for 2 examinations,
Yes,
the district judge and the civil judge,
yes,
you get selected as a junior division. So that result comes first
yes,
and you join that.
yes.
And thereafter, when you are also selected for the district judge, the result comes 6 months thereafter.
According to that, I'll be disqualified. Because I must be 7 years on the date of appointment also.
Matter is there.
That is the fact.
Kerala matter is there on this surface.
Facts in Vijay Kumar Mishra.
Because-
What your lordships have recounted are the facts in Vijay Kumar Mishra, which was answered in favor of the petitioners by saying that you can resign and join because they contradistincted between the process of selection and appointment.
Because the qualification will have to be as on the date of the application.
Exactly. That's my point. It did not go. And number 1. And secondly,
Lordship rightly said, my lord, if question 4 is answered in our favor, that combined,
Yes.
then he also sails through.
Yes.
Well, then we were not, because that may open up Pandora's box. Suppose like Nandi Brother point was, suppose if you have a 7 years experience, then you give up your practice for 10 years and do something that you go to films or
Or no, for example, no, Lordship,
or
yes,
some
a sabbatical.
open a restaurant or something,
Yes.
and then after 10 years, you say that I'm coming back to the practice, and now count that 7 years experience
Lord,
of 10 years back.
no, suppose I practice for 10 years and then I join, say, I become a lecturer in a college. And then I decide to write the exam. What is the bar? Number one. Number two.
But then I say, bar would come because you disconnect with the practice.
legal process.
Say, you
No,
can't
no.
just go, maybe connected with the institution, connected with something.
So that's the point, Lordship.
Technical officer, that's all that you
No,
can't.
what my
We
submission
we can understand if you.
If you practice as a lawyer.
If you are a public prosecutor
Yeah.
or an additional public prosecutor.
that is Deepak Agarwal's case, public prosecutors. No, what I'm submitting is one submission.
Or what, for that matter, a law officer. Law officer, so continuing with your legal profession.
No,
But-
my
but
submission,
Deepak-
once I finish what I'm proposing for saying is this. Once on the facts of my case, my lord, what they say is, on the date of your appointment, you had not practiced for 7 years. I had practiced for 10 years, then I became a judge for 4 years. Again, I practiced for 5 years.
That's a different issue.
That's the problem.
That will cover what we.
If we answer question number 4 in the affirmative,
Yes, yes.
then you will stand
But-
concluded.
But my other question is this. As my lords mentioned, ultimately the aim is to get the best possible pool for selection. Get in terms of quantity, you'll get the quality also. If you get a larger pool of consideration, you may get a better quality. What I'm putting to your lordship is this. As far as my client's facts are concerned, if your lordship accepts me, it sails through, no problem. But 2 points are there. Whether Dheeraj Moore is right in saying that the 7 years should be continuous on the cutoff date on date of appointment. That's one.
It's very clear. I think the
It is the date of appointment, the date of application.
Nobody
enough.
can say that's appointment.
So lordship will just
Unless
para 45.
Because it is so there.
Exactly. No, if your lordship, then I will save time. The other larger question I'm saying is this, my lord. Suppose, my lord, please see para 45. Please see para 45 first.
Yes.
Straight away at page 37 of my submissions.
Sir.
You're reading, Dheeraj?
Dheeraj Mohan. And the same thing is reiterated in the conclusion. So I'll just read para 45. In view of the aforesaid discussion, we are of the opinion. Para 45, reproduced at page 37 of my written submissions. Para 5.1.
Yes.
May I read, my lord? Lordship's got all of it. In view of the aforesaid discussion, we are of the opinion that for direct recruitment as district judge, as against the quota fixed for the advocate/pleaders, incumbent has to be practicing advocate and must be in practice as on the cutoff date and at the time of appointment, and he must not be in judicial service or other services of the union or state. Full stop.
If we answer for this goes,
Yes, for constituting, correct. That goes. I'm only underlying the portion from my client's perspective, which is I'm just put. But since your lordship is in the constitution bench, we're getting a golden opportunity of completely interpreting 233(1) and 2, my lord. So that my humble request is let us consider all the ramifications so that this guidelines for the future also. Because after this, then if your lordship wants laid down the law, then it's completely settled. There is no other judgment of 233 except the old Rameshwar Dayal and Chandra Mohan. For constituting experience of 7 years practice as an advocate, experience obtained in judicial service cannot be equated combined, and advocate pleader should be in practice. Now this is the problem. Should be in practice for the immediate past for 7 years and must be in practice while applying on the cutoff date fixed under the rules and should be in practice.
answer for in the affirmative. This is
Correct. So that date of appointment will go.
Totally go to wash away.
On merit, we are with you, as my brother has pointed out, 217.
Yes.
That takes it. For a lawyer, services rendered as judicial officer can be counted even for constitutional court.
Yes.
And then the absence of any rule, any mandate under Article 233, it goes without saying.
So, my lord, if your lordship sees the box, the facts are given, I'm clearly coming
Vice
with.
versa will be a problem.
Yes, exactly. My lord, I'm also canvassing a larger problem because I'm just looking at this way, my lord. Today, my lord, the service conditions are very attractive for a district judge. The salaries are good. The service I was a junior. Now, my submission is this. The 233 says 7 years. Why 7 years? Because they want to fix a legislative period of maturity. For High Court, they say 10 years. For this thing, they say 7 years. So that doesn't mean at 7 years you can become. That's only eligibility. They say that till you are 7 years, you're not even considered to be eligible to be a district judge. And for Munsif, your lordship had put 3 years before. All those questions are there, whether they could go straight from the law college or they must serve 3 years.
Who has answered that?
Now you answered that question. So now there's a gradation. For the lower level, 3 years, district judge 7 years, High Court 10 years. This is the mantra. Now my only question is this. What happens to a case? Suppose I practice for 10 years. Now, suppose there's a break. Suppose I practice for 3 years. For various reasons, I may decide for financial reasons to take up a job. Because I know in my own case, and when I was in Madras, there's a lawyer who practiced for 2 years in financial difficulty. He joined a company for 11 years, then resigned, and because he had saved money, and then practiced for the next 35 years as a successful criminal lawyer. Now, suppose he's practiced for 3 years, taken up a job for 9 years for financial reasons. Again, he comes and practices for 6 years.
Let us not
Don't,
mistake
I'm saying
people.
don't 7 years continuous. Please consider it. I'll tell Lordship why. Because 7 years continuous not necessarily should be because the Constitution doesn't say so. It says practice for 7 years. What is the magic or what is the thing of 7 years continuous?
That will be, going
Difficult for us to
to
accept.
be difficult for us.
Here it has been rightly interpreted that Shetty
He has been in practice. Please see 233. I'll just,
proceeding that 7 years, that's all.
but no, should it be continuous for 7 years? Should it be continuous? No, but I'll tell Lordship why. In Article 222, when transfer came in Sankal Chand Seth's case, the question was whether the transfer could be without the judge's consent. That was Mr. Sirwa's argument. Yeah.
We don't go by your factual scenario in your case. What the argument you are making is very difficult for us to accept. For example, say what if somebody is there not practicing for 6 years and 11 months, and 1 month is practicing. You wanted that earlier practicing period to be taken.
No, I'm not taking that. I'm not.
Continuous only.
No, the point is that will come in the question of suitability.
There's a disconnect. You must reconnect for and be there for a reasonable time. And then if you say this, take into past function as a lawyer.
What I'm asking is question is, suppose I practice for 10 years. Suppose I practice for 10 years. I've completed 10 years. 10 years continuous practice I've completed. And then I join a particular service, say the law, and there I can always apply lordship because now the question is, should I be practicing advocate on the date of my application? My point is not necessary so.
On the date of application, you have to be.
What mean?
On the date of application, you have to be a practicing lawyer. Either a practice, if you hold in your favor, either a practicing lawyer or in service of a union or a state.
Has been a practicing lawyer means you have to continuously state that's clear. See,
On the date of application, you have to be.
No,
Maybe not on the date of appointment.
Yes, it's split. Split should
no,
not.
I'm not talking about split. I'm saying suppose I work for 10 years. Now, my lord, the point is that person has jurisdiction can become a Supreme Court judge. I'm just asking myself the question. Please say Article 233.
Don't equate a jurist with.
No. Unfortunately, my lord.
Unfortunately, somebody has been able to make it so far from that category.
No, I realized that 42nd Amendment dropped jurists in the High Court position. It was there for High Court and Supreme Court.
Earlier, High Court also it was.
No, not then.
So, suppose, for example, if somebody practices for 3 years and then thereafter runs a bar for 10 years
Yeah.
and thereafter practices for 1 year,
No.
should that be taken into consideration as the entire experience at the bar?
No, I'll tell Lordship, Lord. It's a very good example, Lord. He's continuously in the bar. No, Lord, what I'm submitting is, take your Lordship. No, Lordship will kindly see. No, please see it, 233.
Too hazardous.
We'll have.
No. What I'm submitting is 2 questions, my lord. Suppose he has finished 7 years completely. He then takes up
Yeah,
a job,
application, right?
and then he resigns, and then on the date of
We
application,
don't want,
Then
we
it
don't want to accept.
will be still covered by 4.
Yes.
that's enough.
If 4 is answering the affirmative, then it will be covered by 4. 3 years practice, 3 years in service, again 2 years at the bar.
Judicial service.
Judicial or public prosecutor or
I'll put it this way, my
law
lord.
officer or something,
No,
something to do with law.
Yes.
No, I'll put it this way. Suppose a person is in practice for 10 years. He joins a tribunal. Because now today the whole difficulty in tribunal, you can't be more than 4 years. No.
It's almost a judicial.
No, Article 217 AA says judicial service is different, the tribunal service is different. It's not a judicial service. See, what I'm submitting is, if a person has finished.
Take a hard case and then lay down law.
No. Because what your lordship lays on principle should apply universally. And only a hard case will test the principle. In terms of physics, a proposition will be correct only if it tested on a hard case. That's why I'm saying. Lordship will just see 233 and I'll not go because my time is up just to, because
There are 12 more minutes. 12 more minutes.
I'll try to finish in before that. Tell Lordship why. Please consider 233, madam.
Yes. Yes.
233-2 I'm on.
Yes.
I'm saying whether we can add the adjective continuous. And that was added by Deepak Agarwal, by Justice Lodha, where he said, it's in the present perfect continuous tense. My submission is there is no present perfect continuous tense. I'm coming to that. Please kindly see para 233-2. A person not already in service of the union or the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. So if a person has finished 7 years appointment, now two questions are there. Whether 7 years should be unbroken, number one, or it could be that he practices for 3-4 years. For various reasons, he has to leave the practice, he works, again he resigns, again he practices for 7 years or 10 years. What happens?
So you have not been a lawyer for 7 years.
If you are not connected with law for
In the aggregate.
Has been, you see, past you can't bring it into the present. That's a difficulty.
No, he has been a lawyer.
Honorable Chief said, on the date of the application, you should have put in continuous 7 years, and on that day you should be a lawyer. That's all.
either a lawyer or a member of the service.
Malad, I'm grateful. Lordship is now clear. Let's not go to date of appointment. Let's fix to date of appointment.
Date of publication.
Date of application.
Like the example we gave you.
I don't think they can put that also.
Yes.
If two applications are held, two selections are held simultaneously, the JMFC and one appears for both. The JMFC comes earlier, he joins.
Lordship will just.
After 1 year.
Correct. Unjust.
That can't be to the detriment of a person.
And the person who applied, he can't indefinitely wait till the appointment.
Wait till
Exactly. I'm only requesting my lord to say that 7 years, it need not be non-stop for a person.
That we are saying combined. We are saying, if we answer in the positive,
Yes.
we say combined 7 years experience. So it could be initial 2 years as a lawyer,
Yes.
then 3 years as in service. You resign from the service, again you are immediately start practicing. Then you come have 2 years of
5 years.
practice.
3 plus 5, 8 years.
Plus 2.
Yes.
It makes out 7.
Yes, enough. So Lordship will say that it's in the aggregate, not continuous, because what? No, I'm requesting Lordship. No, because, no, kindly.
If there is a disconnect from the legal,
No. No, Lordship will kindly see, not judicial, he could be a public prosecutor.
that is,
Number one.
public prosecutor, even for that matter, a law officer with, say, public.
Suppose he's working as a legal manager in a company, corporation. Suppose he works
He
in.
will not come. He is an employee that can't not come.
All right. Lordship will take, suppose a tribunal member, please come to 217 AA, 217(1). So now, Lord, just to clarify, since we're laying down the rules, it can be aggregate 3 plus 4 and a break can be towards the judicial service. I'm only submitting, suppose it's a tribunal service, kindly come to 217 AA.
Yes, please.
217, explanation. Now in computing the period, see, kindly come to 217, explanation AA. In computing the period during which a person has been an advocate of a high court, they shall be included any period during which the person has held judicial office or the office of a member of a tribunal or any post under union or state requiring special knowledge of law after he became an advocate. So now, Mala, today when there are so many tribunals and the appointments of 4 years.
Tribunals we may include.
No problem.
Yeah.
See, it says member of the tribunal.
Tribunals or even a post
No, Mala,
requiring the knowledge of law.
I'm not
If
just mentioning judicial service. I'm saying extended to tribunals also.
The article
no.
itself says member of the tribunal.
It is normally.
217 AA, it's not said in 233.
If a person.
That's what I'm saying. So according to your lordship, Lord, suppose as a lawyer, for various reasons, I take up a job as a law officer in a company, as a legal man, that will not be qualified. In a public sector undertaking also, no. I take it that way?
Yes, but if it is in union, by giving an interpretation to AA,
Yes.
we can include a person
As a
who is
tribunal member.
in service under a union or a state requiring special knowledge of law, like under secretary, law department.
Or this is legal remembrance. Like
Legal
V.S.
remembrance.
Deshpande.
We have had
No, just a V.S. Deshpande was also legal remembrance.
V.S. Deshpande and Justice Vaze.
Yes.
He was a law secretary in the Union of India, law secretary or additional law secretary. From there, he came to Bombay as the judge of the High Court.
Yeah, no. Yes,
So we can,
VV Bazet.
by giving meaning to expression double A,
Yes,
we can include this category of candidates.
yes. Sorry, Manoj.
But that will create complications. A person is in JAG branch, Judge and Advocate General branch, whether he'll be included or not.
Yes, you will be included, you will be in the service of Union.
You know.
You will be in the service of Union if you
It
are.
could be in the judicials. Yeah, your lordship is right. Army, JAG,
Can
judicial,
apply for a
JAG
constitutional
branch.
post. Whether when it can be applied for a constitutional post.
Why not? By logic, what is it?
Yes, the same logic, it can't be otherwise.
But not beyond this. Otherwise, then the combined experience of 2 bars.
Yes. So, no, Lordship will just see what portion I wanted. So this portion of para 45. So that second point is correct. The earlier point, Lordship will just take.
No, if we hold that the experience in any of the categories provided in double A
Yes,
would also be included,
yes,
then it will cover
that will
everything.
solve the problem. And Lordship will kindly see, your Lordship also to clarify that practice should be immediate pass for 7 may not be necessary. Continuous for 7 years may not be necessary. If there is a break,
No,
break the judicial service.
break on account of any of
Yes,
the services.
exactly. Because in Deepak Agarwal, para 102, they say, your service of 7 years should be unbroken before on the date of application, which may not be correct is my humble submission. Kindly come to Deepak Agarwal page, para 102. And that is what is followed by Dheeraj More. Please come to Deepak Agarwal. One page.
No, we will say that, say, first, as Honorable Chief said, it will become unbroken. If you add with both these two, it will become unbroken only. It will not break. Whether you work as a lawyer or a judicial service, it will not break.
Whether work as a lawyer
Continue
plus
service.
217 AA categories.
That's correct. Only to that category.
Only to that.
That category, yes.
Yes. So Lordship, to that extent, 102 of Deepak may have to be overruled. Kindly come to volume 5.2.
Yes.
Volume 5.2.
Page 86 of the current combined.
Okay,
Which
fine.
I've just handed over.
Can I borrow?
Yes, sure. Page 86, you can take this, that's my part. You're okay with that?
Yes, yes.
Deepak Agarwal.
Yes. At page, there was a question of whether public prosecutor, government leaders will also be included. Lordship will just come to Deepak Agarwal. Lordship will see the first page, at page 32 it starts. The question before the court
1 minute.
is set out at page 42. Lordship, page 42, Milord.
Yes.
So Lordship will know what is the controversy at page 42. May I read, Milord? Leave granted, that part,
One minute.
page 42.
Page 42.
Yes. Page 42, may I read, Milord? Leave granted. What is the meaning of the expression, the service in Article 233(2) of the Constitution of India? What is meant by advocate or pleader under Article 233(2)? Whether a district attorney, additional district attorney, public prosecutor, assistant advocate general, who is a full-time employee of the government and governed by and regulated by statutory rules of the state and is appointed by direct recruitment to Public Service Commission, is eligible for appointment of district judge under Article 233(2) of the Constitution. These are the questions. And they answer it in the affirmative. But problem, para 102, my lord. Read, my lord, 102 at page 86. As regards, may I read? All lordships have got it?
Yes.
As regards the construction of the expression, if he has been for not less than 7 years as an advocate in Article 233(2) of the Constitution, we think Mr. So-and-so was right in his submission that this expression means 7 years as an advocate immediately preceding the application and not any 7 years any time in the past. This is clear by the use of has been. The
So once
present
we hold that combined experience of
Yes,
a lawyer and a judicial officer and any of those categories
yes.
mentioned in explanation double A.
So he need not be an advocate per se, because this paragraph says in Deepak Agarwal, advocate for continuous 7 years, which may not be correct. In your lordship's formula, advocate plus 217 double A plus, I could, 3 plus whatever it. That's, so this paragraph may not be correct. This has been followed in para 45 of Dheeraj More. So lordship may, because even what the lordship said, present perfect continuous tense is not correct. It's present perfect tense. If you say present perfect continuous, there must be a verb. Yeah, yeah, ing. Present ing, ing. So we check Ren and Martin after a long time, my lord. I'm sorry to say, my lord, my children, there's no grammar in CBSE now.
They don't understand what is Ren and Martin.
No, there's no grammar in the syllabus now. Yes, not unknown, yes. So, my lord, my submission is my client's facts comes squarely to the point. She has finished 9 years, 4 years judicial service, and again 5 years. Therefore, selection should be. She was discontinued on the basis of para
But
45
we
of
won't be
the.
deciding the question, we won't be deciding the individual.
Yes. So, lordship, last 2 questions which I have raised, that lordship see if whether lordship wants to deal with them in my written submissions. Just see the last page. What I have done. Just.
State of application.
Page 39 of my written submission. My humble request is page 39, whether 7 years in Article 233(2) means 7 years continuous. Lordship may say it is 7 plus judicial, 3 plus judicial.
Yes.
And the cutoff date should be taken as date of application. Those questions Lordship may add and answer them also. Those 2 questions can be
Not
added.
necessary to add in our discussion, we'll.
No, I leave it to you. For clarity for future, it will be obliged. I have also finished on time.
Because it's not the taxation matter.
Can I have my compiler?
Sorry.
That compiler.
Yeah, sorry.
Sorry.
Yes,
Yes, I will.
Will keep us away.
I will actually finish within my time because my work is much lightened because I am in the same category as Mr. Datar's client. But there is just one aspect I want to highlight, taking off from where he is left.